Several years ago, I'm watching a football game at the end of the season. Huge game for each team. Winner goes to the playoff, loser, they go home. The color commentator on that game was Steve Young, former quarterback of the San Francisco 49ers. Well, the play-by-play guy says, Steve, you played a number of huge games for Coach Bill Walsh with the 49ers. What would he tell you before a big game like this? And I'm thinking to myself, Bill Walsh, he's a smart guy. Coach at Stanford, he developed the West Coast offense. When they wrote a biography about him, they entitled it Genius. Bill Walsh must come up with something from Shakespeare, the ancient philosophers, something intellectual. Steve Young said before every big game, Coach Walsh always told us the same thing. Hit them first. Well, in today's trucking environment where the situation allows us, we have to go forward and sue them first. Several reasons. Number one, jurisdiction. There are those jurisdictions out there that are just totally plaintiff friendly. And in any case in which we have the opportunity to anchor jurisdiction, where the accident happened, often in a rural, less plaintiff friendly jurisdiction, well, we can do that in many states by filing the suit first. Now, in order to do that, we have to have an argument, have to be able to assert a claim that they're liable. And secondly, we have to have some damage, PD or cargo. But if we have an argument that they're at fault for the accident and we've suffered damage, then we need to sue first in order to keep that jurisdiction for our case in a less plaintiff-friendly venue. Does it make a difference? Well, this is what Rebecca Brewster said they found at ATRI when they did the study of nuclear verdicts.
Case.
Well, like in real estate, location.
There you go.
Where you try that case makes a difference. And so,
well, jurisdiction is one crucial element. That's why we do this, but there are others. Second reason, we want to get the jump on them. We want to take the offensive in this case, begin discovery rolling, get subpoenas out there, possibly even start to take depositions. And in doing so, because it's our lawsuit, that case, the plaintiff is going to be represented by an insurance company attorney, not a billboard attorney at that point. Now, maybe that other attorney will jump in, those who advertise and look for cases against big trucking companies, but we've gotten it rolling. We've taken the offensive. We're the ones who get to jump on them on that. And a final reason? Well, if we take action and get it immediately, we have a chance of cutting off that claim entirely. Let me tell you a story. Several years ago, my truck was involved in an accident that had two other cars involved. But our camera showed that the two cars were actually the cause of the accident, moved over in front of the other and caused a collision. Well, I brought suit first on behalf of my trucking company against the drivers of the two cars. We had property damage and we had cargo damage at the time. Well, we went to arbitration in that case early on, had the video right there for them, and the arbitrators came back 50-50 for the two cars being liable in the case. No liability on us. After the appeal period ran, we had a judicial decision that bound those people who were involved in the case that we were not liable, cutting off any lawsuit that they had. Look, I know for many people it's a foreign concept. The notion of us suing the other car, suing the other driver. But for the reasons of jurisdiction, get the jump on them, and perhaps even cutting off the claim, you've got to be prepared to sue them first.